the channel and thank you for watching. A very interesting video for you today, and we have a sponsor for this video, but more about them later. So as I said, today a very interesting conversation. You have myself and our Alan Robert Shaw here. How are you doing today, Al?
Really, really well, and glad to be back on air. This is a nice diversion from like real legal work that keeps intruding.
Absolutely, likewise here. Today we're going to talk to you about quite a number of different things which are floating around on social media. We're going to talk about meters and whether it's legal to remove it or have someone else remove it, or otherwise circumvent it with your energy supplier. We're going to talk about the Strawman idea. We're going to talk about common law and statutes and maritime law and Magna Carta and all sorts of other different things that come into the segues in the meantime. So, as I said, all of these things seem to float around on social media, and I feel it's somewhat of a public service of mine as a barrister to bring these things to you in videos, to tell you what is and isn't law, what you should and shouldn't do, all of which not legal advice. For reasons we've already said before, we cannot give you legal advice because you might rely on it and then sue us. So it's not legal advice, anything that we say. It might be guidance and it might be the best do's and do nots, but not advice. First up on the list is meters. I noticed Martin Lewis tweeted about this some time ago, and it's still doing the rounds. People are saying that they can remove their meter, albeit even if they get somebody qualified, as in a qualified electrician, to come and remove their meter. And then somehow, I think one TikToker even said, then it's free. Now, I don't understand the logic as to how they believe that it's free, but Al, your reaction to this, please.
Yeah, I mean, first of all, it's very simple. No, you cannot do that. And there's lots of reasons you can't do that. You are committing an offence. It becomes abstracting electricity. Unfortunately, the electricity isn't free. All the companies, they put certain amounts of energy into the grid, and then their customers draw down on that energy, and then they bill their customers. Removing the meter, just basically, first of all, you're committing the abstracting electricity offence, which is a specific type of offence, stealing electricity. Also, there are lots of health and safety and regulatory offences. Now, if you do that yourself, then you're committing those. But even if you engage somebody else to do that for you, and no qualified person is probably going to agree to this anyway, but you are aiding and abetting that offence. And this is coming back to this idea, we know people are in very, very dire straits, and we might be able to offer some slightly more practical advice on what to do. But this is one of the dangers of getting your legal advice from sort of questionable sources, because it exposes you to risk, both legal risk and, in the case of trying to take your meter out, sort of, risk of electrocution. So what I can say is, you just don't do it. There is nothing in that. There's nothing in that. You're removing the meters does not remove the liability for the electricity.
And just to pick up on something you said there, Al, which is absolutely fundamental, is even if you engage someone else to do it, and as you quite rightly said, Al, no professional worth their salt would engage in doing such a thing. That's not to say some won't. You will probably get some, I dare say, who are authorised and certified and everything else that will be prepared to do it for some sort of fee. A lot of people do various things for various fees, but regardless whether it's you or you're engaging someone else to do it, this is strictly not permitted. And so, as I said earlier, a brief word about my sponsors, NordVPN, who help to keep my channel going and growing. And while I do that, you get to observe just what a good girl the black belt floof really is. And she can sit here and be in the video too. So why do I use NordVPN, or any VPN for that matter? Well, I genuinely use NordVPN, and I've paid for it myself for over 2 years. I've said on this channel before, I wouldn't mention anything to you that I don't genuinely use myself. When you visit any website online, there is a DNS lookup, which looks up your IP address, which potentially allows other people to see where you are and track you and track your activities online. Not only that, there might be malicious scripts on websites that you visit, and you might be completely unprotected whilst you're online. In addition to that, you might want to visit websites that are only available in other countries, or watch films or programs that are only available in other countries. NordVPN allows you to change virtually your location, so that if you're watching certain video streaming platforms, you can virtually change your location so you can watch those programs in various different countries. There are also various other packages available which have different options, such as storing your passwords, and you can use it on all of your devices, so not just your laptop but your phone, your iPad or your Android devices as well. And you might have spotted by now that there's a link on screen which is also in the description below, which if you click that link, it's my unique link, you get an additional bonus month on top of the 3 months that's currently being offered. So you'll get a total of 4 months of an exclusive discount because you clicked the link by watching Black Belt Floof here and then click the link in the description. Now, many of you might be wondering whether it slows down your internet or anything like that, and I can genuinely say that it doesn't. Believe me, I upload a lot of material, particularly to YouTube, and large videos at that. All of my videos are uploaded in 4K. But NordVPN is blazingly fast and doesn't slow down my internet connection whatsoever, which allows me to bring super high definition videos of the Black Belt Floof to you just here, and you can see just what a good girl she is sitting here through this video. There is also a money back guarantee, so that if you don't like the service you can just cancel it and get your money back, but believe me, the peace of mind knowing that you have this VPN in place so that others can't track you online and you'll be protected from malicious scripts and things of that nature, the chances are you won't want to give that up once you've tried that out, and it gives you that peace of mind whilst you're online. So as you can see, the link on screen, it's also in the description below, which helps you to go through very quickly for your exclusive discount. So thank you for allowing me and the Black Belt Floof the time to thank our sponsor for this video. And now back to the video. Other comments that have gone around online have been that the supplier can't force you to have a meter, or they can't control it, but actually they can, because all of this, as I have said in a previous video, is all covered under the Electricity Act of 1989, Schedule 7 in particular for the use of meters, literally, etc. It says so anything to do with a meter, and all this essentially says where there is an authorized supplier, which is just an energy supplier that's been authorized, is going to charge for the electricity or even part thereof, then it will be done, it shall be done through an appropriate meter, and that will be decided by the supplier. If they agree to a different one, that's fine, and that's this bit here. If the authorized supplier agrees to the meter provided by the customer, I always want to say consumer, but same thing. Not always the same thing. Customer might be a business, by the way. So this could apply, actually does apply just equally to businesses. I just say consumer, but consumer, strictly speaking, is not a business, but that's another story. It shall be done with their own meter unless they agree to their own. And even then, it's got to be done the way that they say. And if not, then they may refuse to allow one of the customers to provide the meter, and otherwise they might just switch it off. A lot of people are saying they could not switch it off. That's not true either. This legislation permits them to turn it off. It permits them to switch it off. Some of the social media posts have said this is a right to have electricity. Sadly, it's not a right. It's not a right to have it's important to distinguish the difference between a privilege and a right, options and a right. I mean, there are some views on whether this should be renationalized, but this is not a right, is it, Al, to electricity or gas for that matter?
Unfortunately not, no. I mean, your basic rights, if you read the ECHR, the Convention on Human Rights, that sets out a lot of the rights. And they're in very broad terms, the right to life, the right to privacy, the right to establish a family. Now, sometimes you can argue and say, well, in order to satisfy that particular right, you must impose some legislation to do this, or you must prevent your government bodies doing this. The other thing to remember about sort of rights generally is it's all about the state, and it's the state interfering with your rights. Now, at the moment, the electricity companies, they're sort of semi-private concerns. Now, there is an element of sort of public ownership and public interest into it. Yeah, and the government obviously does have a bit of control over utilities companies, and that's done in terms of how they put the legislation in there. But the companies, effectively, they are allowed to operate within the limits of the legislation, and that does give them a lot of powers. Now, there are sort of schemes in place where they can't necessarily disconnect you if it's going to cause exceptional hardship, things like that. But starting position is you are expected to pay for a service that you use. And, we get into lots of issues about this. The fact that, buying on a key meter works out about 8% dearer than buying on paying just by direct debit. Now, that does actually bring us into something. Now, this is not legal advice in every sense of the word. Because the wonderful Jack Monroe, no doubt a few other people have pointed this out. If you are in dire straits and you're worried, it's a choice between do I pay my heating bill or do I feed the kids? One thing you could do, now you're not allowed to do this is a breach of contract, is you could cancel the direct debit facility. So the electricity company can't just take out any sum they want. And you could instead either pay a specific amount you can afford or set up a standing order using the same account details. Now, that is a breach of contract. You're not allowed to do that legally. However, in terms of, it's the same with dealing with any creditor. It's always better to be paying them something rather than just nothing. Even if you can only pay $5 a week or something, because while there is money coming in, people are often, at least it shows goodwill and there is some communication and some hope for things changing in the future. And also, if you do go to court, you're going to get the sympathy of the judge because you've not just buried your head in the sand about this and said, go away, I'm not going to pay it all. You've said, look, this is literally all I can afford to pay. And let's face it, if they were to bring a claim against me and succeed, and you were going to say, yes, you owe them all this money, I could probably argue, because one thing judges do have the power to do in orders is give time to pay. Either a time limit or to pay regular instalments. So you say, well, you're probably only doing that anyway.
Yeah, and the judge is much more likely to give time to pay. Yeah, if they've paid something, much more likely to allow time to pay them, because as you just said, they're doing that anyway. Burying your head is always not the ideal thing to do. It doesn't matter what the situation is. Burying your head is... I spoke to somebody just recently, fairly substantial CCJ some years ago, for something. When they told me the story, I was, wow, it was quite silly. It was absolutely slam dunk case to successfully defend it, and there would not have been a CCJ, but head in the sand, I'm afraid, and the CCJ is there. So there it is. Burying your head is never the best idea.
If you ever get to the stage where a claim is issued, where they go to court and a claim form arrives, it arrives with what they call a response pack, and that contains various forms. If you ever get a claim form, by the way, that's just the claim form, particular claim, and no response pack, that doesn't count as good service. So, sit on it and go to limitation and go to the court and say, I was never served properly. No, and people do that, because weirdly, that is a very strict requirement. But the response pack contains a number of forms. It contains an acknowledgement of service, where you can tick and say, I am going to defend this claim. It also, though, contains an admissions form where you can say, I admit this claim, or I admit part of this claim. But as part of that, it includes I would like time to pay. And it's basically, you fill out, I've got to stop saying basically, you fill out sort of your expenses, your income, your outgoings, and you propose an offer. And you send that off. So you've admitted the claim, but then the judge gets that and goes, okay, they've admitted the claim, they want time to pay, this looks quite reasonable, I'll just make an order saying that. Or sometimes the judge might say, well, I'm not going to give you 2 years, but I'm happy to give you 1 year. So that is always an option. But ideally, you want to avoid getting to the stage that a claim is issued, because, again, that is, you've got a county court judgment there. Yeah. Because even if it's effectively agreed by almost consent, in that you're saying, yes, I do owe this money, I just want some time to pay, you can probably come to an arrangement to do that anyway with a utilities company. If you say, look, I am completely struggling here, but here's what I can offer to pay.
It's always better to talk. And whilst, you're right, Al. I think whilst all of the energy companies, now this is not a defence of the energy companies, nor is it against, it's a neutral point. But whilst there's been a lot of heat, no pun intended this time, against the energy companies for all of this, they will probably and would see the sense in talking to you about payment in instalments, because it is in their interest to keep things going and to not get the negative publicity and not switch you off and all of that sort of stuff. So whatever you can pay them, even if it's over time, they are probably willing to talk to you. And if they're not willing to talk to you, I think that's pretty poor, frankly. And then they would deserve the negative publicity that would ensue from that. So yeah, there's a number of ways of dealing with it, but burying your head's not one of them.
Yeah, but get something in writing. Write to them and say, look, your stance I think is unreasonable. This is all I can afford to pay. This is what I am offering to pay. And if you issue proceedings, that's what I'm going to be saying to a judge. And then if they do issue proceedings, you say, well, look, this is what I said in my letter. And the judge will probably say, well, they would try. And unless your offer is completely unreasonable, a judge is quite likely to say, yeah, that sounds fair enough, because they recognise the realities and the hardship of life.
Yeah. And so just to reiterate, you cannot remove your own meter. Not only would that be dangerous, but it would be illegal. You cannot get someone else to do it because you need the supplier's consent. Again, I've seen lots of contrary views all over social media. And, without any desire to blow any trumpets, we are literally qualified to tell you this. Not that this is advice, but we can tell you that is illegal. You can't get someone else to do that. You need the supplier's permission. And even if they give you permission, which they probably would, depending if you wanted to move it. So let's say you're having an extension or something and you need the box moving, and obviously you need the meter moving, then you will need the energy supplier's permission, but they will probably give you permission in that situation. You could possibly get a different meter at the same time and this sort of thing. There's also questions, your views on this might be interesting as well, Al. There's other arguments and questions flying around as to whether the energy supplier can force you to have a smart meter. Now, again, this comes back to the same piece of legislation. It comes back once again to this, in my view, and then Al can give you his view. So this, again, is going to be a meter which is ultimately decided by the energy company. So what's your view on that, Al?
Yeah, again, they have a statutory right to decide what meter you get. Now, obviously, they do offer, the different options, but they quite often they can force you to go on going on a smart meter is possibly not the biggest problem. It's being forced onto a key meter because, as we said, the trouble with the key meter is it works out about 8% dearer on average. It's very expensive being poor because you are penalised, and also the fact that it can run out, and then you're left in the darkness, and that is a huge problem. Whereas it's to actually disconnect you or turn off, there's quite a complicated procedure they have to go to. I mean, ironically, one group who can remove meters are the utility companies, but they have to get a warrant to do that. And again, if you ever get a notice saying we are applying for a warrant of entry to remove a meter, respond to it. Respond to it. Don't just sit there, because one day chaps are going to turn up, and the next thing you know, all your electricity's gone off. When you get that form, they actually do say, look, if you've got any sort of reasonable offer or argument about this, let us know, we won't pursue it. It says that on the actual warrant form, and it says we can probably sort this without having to go to court, but you do have a right to go down to court if you can't sort it, turn up on the day. But you have to let them know, by the way, you have to let them know that you are contesting it.
You can't just ignore
apart from it. It's just for listing as well, because if you ever go down to a day where there's a court doing a list of warrants, whether it's utility meters or television licensing, anything like that, what you tend to find is there'll be a list of about 100 cases on, and there'll be 4 people actually turn up. And quite often, if you turn up and speak to whoever's instructed to act as effectively the prosecutor and say, look, here's what I want to do, you get to speak to a human, and quite often they either have some authority themselves or they can get in touch with people to get authority. And they can actually do deals on the day. And the fact is, the mere fact, you turning up shows that there's some willing. You can get in front of the bench and you can argue the case. But so few people actually do turn up to contest these. Again, most people just bury their head in the sand. So you have 4 people where they'll turn and go, okay, we've sorted that, we've done a deal, we're happy with that. For items number, the next 96 items on your list, can we just have the warrant, please?
Yeah,
there's nobody here to contest.
So bottom line, don't bury your head. Talk to them, respond to it, especially respond to court, respond to requests for warrants. Don't do the meter yourself. Don't get someone else to move the meter. And just for all avoidance of doubt, putting in another meter does not mean the electricity or the gas is free. It just isn't. That's just not how it works. It's just a falsehood spread online.
Just one thing, this is again not legal, but there are a number of, they keep this very quiet actually, but there are a number of hardship payments available. You can't just apply for them yourself, you have to be referred by somebody else, but your GP can refer you, the Citizens Advice Bureau can refer you, lawyers can refer you as well, although then you're paying lawyers. But yeah, if you pop down the Citizens Advice or your GP and say, look, you know, if I don't have heating, then it's going to affect my health physically or mentally or whatever, or you go to the CAB and say, look, you know, this will cause hardship, won't be able to feed the kids, they will sign the relevant bit of paperwork, and you can get, it's not a huge amount of money, but it can go towards like at least alleviating some of the hardship. So that's something to check out. Like the forms are available online. It's not something they publicise, which is, you know, perhaps understandable why the Treasury doesn't want to part with the money, but that scheme is available.
Indeed. And just as a final point on this before we move on, if you see videos online where people are saying that the energy company has just come in without any notice, without any information, any warrant, anything else, they've just come in and they are forcibly removing the meter, the chances are, I can't speak to any one particular example, of course, because I don't know all the facts, or any in most cases, but there is almost always going to be a lot more to the story than you see on that video. There's almost always going to be a long history. We've each, as barristers, we've each been there in court where we've only seen the very tip of the iceberg of what's happened in the case. I saw the 25th, I think it was, application in a long-standing process, and I was only told about that one. And of course, the judge told me differently. So I got to hear about the other 24. But there we go. So there's always more to it. But this moves very nicely into a lot of other falsehoods that are spread online. One of the very, very broad ones covers 2 or 3 different concepts. The strawman concept that we're going to talk about, common law versus statute, maritime law and Magna Carta. We can talk about all these sort of together, I suppose, but starting, I guess a good place to start as any is the strawman idea or the strawman concept. So here's what a lot of people think it is, and then I was going to tell you what it really is. So a lot of people talk about the strawman idea as though you have a separate legal entity to the name that you're given, so that you are a person or a human, not a person, and there's a name, that the name is the one you're given, and you are somehow signing a contract with the state when you accept the name, or your birth certificate is signed, or if you answer to that name as opposed to disengage yourself from that name, and you are therefore not under anybody's rule. That's one interpretation. The real one, however...
Yeah, strawman isn't defined anywhere in legislation or case law, but it is a phrase that crops up and has done for a very long time in litigation. Strawman or man of straw, and all it was, it's a colloquial expression for somebody who just isn't good for the money. So you will see references in lots of like guidance for how to litigate, lots of case law where it will say, you know, there's no point suing a man of straw. And all that is saying is there's no point suing somebody, because we come back to this thing, getting you the little piece of paper saying you've won is often the easy bit. Turning that little piece of paper into actual hard cash is where it becomes very difficult. So that's where it's arisen. So yeah, you will hear litigators talk about there's no point suing him as a straw man or as a man of straw, or we need to check this because, you know, that this is something that people do before they sue. They will actually, especially in corporate situations where, you know, there's limited liability and people will just wind the company up if you win. This is something people check. I mean, ironically, with the law, you're better off either being really rich or really poor, because there is something to be said for being too poor to sue, because you know you can't get blood out of a stone, and it's just not worth the hassle. But that literally, that is the only time you'll ever hear actual lawyers use the phrase strawman or man of straw in a legal context. It's just a saying for not good for the money.
And I think it stands to reason that it's been misconstrued, misinterpreted, and then potentially misrepresented afterwards, in the sense that some people do think that it means a separate legal distinction between the actual person and the person on paper. And so, as you said, on paper, again, whether someone is worth it on paper or not is a consideration, whether to sue or not, because if it's a company that doesn't really need to continue, then suing it might be a waste of time and money, because you may never get anything back, including the legal costs. Just as a side note, while I'm literally just thinking about it now out loud, there are two sort of bits of guidance that might be helpful. If you are hit by an uninsured driver or they just drive off and you can't trace the person or anything like that, we do have, in England and Wales, we have the Motor Insurance Bureau that will pick up for claims from uninsured drivers. So that is one potential route. And when it comes to suing companies, if you believe that a company, and Al, you were talking about this just before we started recording, but if you sue a company, you win, the company just winds up, and then they set up another company doing exactly the same thing with a very similar name. There are provisions in the Insolvency Act that make that an offence, actually. Not only is it an offence, but it also makes the directors personally liable. It cuts through the corporate veil, making them personally liable for the debts of both the new and the old company, because effectively they've tried to evade the liability for those debts, and a judgment is probably one of the most severe of those that they can try to avoid, because it's an order of the court to pay money. Any other examples on that before we move forward, Al?
Yeah, although they're called the Phoenix provisions, because the idea is that, it's a phoenix, it's a new company that arises from the ashes of the old. I have to say that Companies House are very loath to engage those. You've really got to show effectively almost like the previous company was set up fraudulently. The mere fact that a company is unsuccessful and struggles in business and goes under, they tend to just go, well, that's just that's just the commercial realities of doing business. The mere fact that a company ends up insolvent doesn't necessarily mean it was badly run. This can actually, though, one thing I've noticed, and I've had some recent examples of this, is lenders they will quite often want, even if Companies House are very happy with what happened, the lenders will go, we want a full history of what happened with the previous company before we start lending on this, because they will look at, never mind piercing the corporate veil, they will go, well, you're the same directors. Yeah. We just want to look at this. Just to get back to another point as well, I can understand some of the confusion about legal personhood. And we've managed to get about 20 minutes in without me bringing in animal rights, because obviously I keep arguing, and my much cleverer colleagues, we keep trying to argue for animal personhood. That is to say that animals have a legal personality and can bring claims in their own right. And one of the arguments we use is, well, companies have legal personhood and they're not real. Yeah. A company, the whole point of setting up a company as opposed to like a partnership, which is just an informal, unincorporated association, as we say, it doesn't have any separate legal existence, although that's complicated. But a company has a separate legal existence. It can, it can sue people. It can engage in contracts. It has, it can open bank accounts in its own name. So, we do have this idea that there is a separate legal entity that's created artificially. And one thing you can do is and this is not to suggest there is anything in all the sort of, those sort of pseudo-legal arguments. You quite often find this with celebrities. They will have themselves as a company, as a brand. So, famous racing car driver might have Famous Racing Car Driver Limited that deals with all their actual promotional stuff, their branding, their merchandising. So that is common. But effectively, what they're doing is they're just having a company set up to run their business, and their business is them. So they are selling themselves. But again, that doesn't get them out of any personal liability. If they get nicked for speeding, they can't say, well, it's the company that will pay the fine. Yeah. It doesn't get you out of any criminal liability. It can actually, the reason they do it is it gets you out of lots of civil liability because you've got the debt protection. If you do, if you engage in some fantastic project to promote yourself and it all goes wrong, at least they can't chase you for the debts. So that is something that people do, but that is completely distinct from this idea that you've got, your birth certificate is something separate. And and this comes back to the point. And, not disparaging, there are a lot of people out there who aren't qualified as lawyers, but who genuinely help people. I mean, there are a lot of people who are sort of help as Mackenzie friends. A Mackenzie friend that's not a lawyer, that's not an amateur lawyer, but that's somebody who can sit with you in court, give you guidance, pass you notes, take a note of proceedings.
So they can't speak for you.
And a lot no, generally speaking, no. Although some judges, if somebody's really struggling, they might say, actually, I think Mr. So-and-so or Mrs. So-and-so...
the judge can grant a limited right of audience to speak. Yeah.
On a case-by-case basis and just for individual hearing. It's not an absolute right of audience. So they do useful work. And some people, there are some people who've had experiences in the law themselves that they want to share with people, and their experiences can be very useful. However, where people are offering, what is just effectively duff advice, the danger with that is, in the early days of these sorts of movements, and they've been around for a very, very long time, although with the internet, they've really come into their heyday. The problem was, judges initially they could see through, if somebody came along and gave some sort of weird pseudo-legal argument, didn't have a leg to stand on, the judges might go behind that and say, well, look, you're coming out with all this nonsense that means nothing whatsoever. However, the person who's trying to evict you has filled out the Section 21 notice incorrectly. They haven't put the right date on it, or they've got the wrong timetable. So I'm not going to make the order anyway. So you've won anyway because I've actually looked at what's behind this, and you actually did have a case, even though you didn't argue it properly. And the danger there is people go away and go, yes, our argument's won. The problem now is there's guidance gone out to all the. What they're saying now is, well, tough. It's up to it's the whole point of a common law system is that it's not judge led. It's for the parties to bring the case they want to bring themselves. And now the courts are saying, if you want to run a terrible argument, well, that's on you. We're behind it and say you might have a decent argument here, and that is the risk you are now facing. That you might actually have an arguable case, but you're not putting it forward, and that's, I think, where this becomes dangerous. And I've sort of said, freedom on the land. At the risk of the comments, to me, freedom on the land is just a way of arguing a parking fine into a jail sentence. You see this so many times where people just irritate and annoy the court. Yeah. So you've got to look at, if that's just on you, you can run any argument you want, but I think you have to be very careful. To me, that isn't fair. There are other alternatives out there. There are brilliant people like the Citizens Advice Bureau. There's the Free Representation Unit. There's various pro bono things run by both the Bar and the Law Society. You can seek advice. It is difficult. It is difficult to get good advice. And that's the trouble with you, a million answers. A librarian can bring you the right one. And that's the same in law. You need to know who you're talking to and what are the sources. So I do understand why people get desperate. But running just arguments that A, are unfounded, and B, just annoy and irritate the court, that's not going to do you any good. And also, there's the longer term thing. There's the wider picture. Court resources are very, very rare. And if you're in there arguing 3 hours about Magna Carta on a parking fine, what about the person who's behind you trying to get their non-molestation order, or trying to stop their eviction, or trying to sort of get, their SEN payments for their kids? You are using the time that perhaps could be better spent. So yeah, this is very much my own opinion. It's not. I'm not speaking as a lawyer. I'm speaking just as a citizen. I think there is an issue there, and also there's the fact that while there is guidance for dealing with litigants in person, we can't take advantage of their lack of experience. There's a case called Barton and Wright Hassel, which was a narrowly decided case that said effectively, self-represented people, litigants in person, are bound by all the same rules and requirements as legal professionals. You don't get any extra leeway just because you're not represented or you're not legally qualified now. You have to comply with all the timetables, you have to comply with all the provisions of the civil procedure rules. In practice, if you make a mistake and you go for relief from sanctions, they tend to be a lot more generous to amateurs than professionals because they do accept, you don't do it day in, day out as we supposedly do. But fundamentally, you will be held to the same standards. You can't say, well, I'm unrepresented, so it's just a free-for-all, I can do what I want. They'll say, no, there are the rules, there are the practice directions, they are reasonably easy to follow. I mean, a lot of general litigation is... a lot of the non-specialized stuff is relatively accessible, and there's a glossary in there now for some of the more obscure terms. And courts will often, so long as you've done your best to comply with the CPR, even if you've got it wrong, so long as you can demonstrate, well, I interpreted as saying this, and that's why I did this. Courts are more likely to say, actually, okay, that's not quite right. Go away and just do it again.
But at least you've looked it up, yeah. And just, I mean, at the risk of people ending up Googling things, which I don't suggest you do, at least unless you use it very wisely. We will sometimes Google things because it's often the quickest way of finding what we want, but that's usually when we know what we're looking for. And knowing what you're looking for is more than half the battle as a lawyer. And so you can generally find everything you want by looking it up. And this brings us nicely on to the distinction between common law, statutes, maritime law, and finally Magna Carta, which we'll deal with at the very end. So a lot of people think that common law is separate and distinct from statutes, legislation, acts of parliament, and that's not really the case. We have a common law system, which all it really means is a judge has made a decision on a given set of facts in applying the law as it is, and the law is an overall body of law which encompasses all of those decisions that have gone before in hierarchy, and statutes, legislation, i.e. acts of parliament, subordinate legislation, statutory instruments and all of that sort of stuff. They all work together. And so what you have is a body of codified law, what we refer to as primary law, and common law working together. And very often we will get an act of parliament come in which consolidates everything, all of the previous decisions, all of the European law that's been imported, regional bits of other law that we want to incorporate in our own. A few great examples of that are the Equality Act of 2010, which lists the protected characteristics, of which, referring to one of your points earlier, Al, being poor is not one. Sadly, being poor is not a protected characteristic. So for someone to say if it's discriminating because someone is poor, that's not true because it's not a protected characteristic. If someone were discriminating because it was an elderly person, yes, it is, because that's a protected characteristic. The Equalities Act is a good example of codified and consolidated law, as is the Consumer Rights Act of 2015. There are lots of bits of law that got brought together. A lot of people still mistakenly refer to old law when they're talking about consumers. The old sort of Sales and Goods Act, as far as businesses are concerned, in certain respects, still apply, business to business, but business to consumer, it's very much the Consumer Rights Act. And so we also have various fairly high-level cases that have been decided based even on recent statutes such as the Consumer Rights Act. And they are then interpreting the law on how it should apply in a given set of facts. So that is broadly common law and statutes or acts of parliament. They are not separate. It's not one or the other. And linking that back to the Strawman idea, it's not as though you can just choose whether they apply to you or not. Which brings us nicely now into maritime law, which is very broadly the same thing. Al, you mentioned, actually you sent me a link, which I'll bring on screen now, which is the only way that what people refer to as maritime law actually applies, which is sort of summarized here.
What we'll have to do, I'll just give it, because, I think people like the historical nerdery, so I'm just going to spend like 2 minutes just going, one problem with using the phrase common law is, like so many phrases in the legal system, it means different things in different contexts. It can generally mean a common law system as opposed to a civil law system. And again, civil is a really strange word to me because that can include criminal. The common law is what a lot of countries like the UK, the US, Canada, Australia, basically anywhere we stuck a flag, as opposed to the civil law procedure, which is more based on old Roman law, very popular in the continent, although for historical reasons they also have a little bit of civil law in Scotland. And interestingly, in the US, most of the states and commonwealths are common law, apart from Louisiana, which is civil law because of all the French people who used to live there. And basically the main differences are that a common law system is it's adversarial in that the parties have their own representatives. They bring their own cases, they decide what witnesses to call, what arguments to run, and the judge is the referee. A civil law system is very much judge-led. The parties have their own lawyers, but the judge decides what they're interested in, what witnesses to call, and controls how the evidence is run. Interestingly, we do actually have that over here in inquests, because inquests and inquiries, by definition, are inquisitorial. And they're a holdover from, when it was all very complicated about, the norms that come in with the law. So the difference between an inquest and a court case is it's the coroner who says, right, here's all the witnesses I want to hear about. Here's what issues I want to see covered. They set the agenda. So we do have civil law. Another distinction is, Dan's just said there's a difference between common law and statute. Common law is just case law as opposed to codified statute. We also have a distinction between something called common law and equity. And because the law used to have a lot of formality and it was very strict and it didn't look at the justice of the issue particularly, it looked at who was legally correct or incorrect. And people said, well, that's not really fair. Yeah, the law is against, I lose on the law, but anybody looking at this would say that's not a really fair result. You could appeal to the Chancellor as the keeper of the King's conscience. And the Chancellor basically had a discretion to go, yeah, I know legally you've lost. However, it's not really fair. I am going to sort that out. Not me personally, but I've got my own set of courts. And we actually had courts of chancery. Mm-hmm. And they ran equity. Now, one problem with equity is, as somebody commented and said, equity varies with the length of the King's foot, because, whoever was the Chancellor that particular week, if they were a soft touch or a hard touch. So it was a bit random. But we did have two parallel legal systems with two parallel sets of courts. But in sort of 1873 and 1875, we combined those and something called the Judicature Acts, which combined equity and common law and said there's just one set of courts now, but they can consider both equity and common law. And I won't go into too many details about that because it's probably a topic for another day. But in law, common law, generally speaking, can only award damages. All your other things like injunctions and declarations and orders of restitution, they're actually equitable remedies. And we'll have a little chat about equity one day because it's fascinating. It's lightning.
Indeed.
And one thing, just a little final anecdote, getting onto maritime law. After William the Conqueror came over here, he inherited a sort of quite diverse, messed up kingdom. There are a lot of different factions. But after he'd been established for a while, he sent out something called the General Eyre, which was a commission who went around the country, and the idea was, let's look at best practice and let's try and get some unified or common law for the entire country. Now I'm in charge. And they went around, but when they got to somewhere called the Danelaw, which is, where the Viking influence was still very prevalent. Remember that, William the Conqueror had only won because the Vikings had been defeated at Stamford Bridge. So the Viking influence was still really strong. But they they went there and said, look, we're trying to establish a common law for the entire country. And they said, well, we can actually see the benefits of that for stuff like commercial contracts and dealing with people in different parts of the country. And let's try and get a common spelling for eggs and things like that. However, we like doing things our own way in the Danelaw. Okay, we like our own, we like dealing with things our own way. Now, what we'd like to do is have the power to make our own laws in our own settlements, And the Norse word for settlement is by, because, like Whitby and Grimsby and all those place names. And they said, okay, so what you want is you want the power to set like local laws. Yes, we want the power to set bylaws. And that's where we get the term bylaws from. So I just thought I'd slip that in as a little anecdote before I go back and say, Dan, we were talking about maritime court.
Yes, indeed. And just as another side note on the bylaws, which I've had reason to look up in respect of drones, because we've got local authorities trying to ban drones by creating a bylaw. But a bylaw should not be created and would not be valid and shouldn't really be enforced or enforceable if it has been created where there is existing legislation that deals with the problem, in inverted commas, or just generally where there's already legislation that exists in that area. And so in this sense, with drones, there is legislation. It's brought about by the CAA and the navigation order, which controls the airspace and everything. And so there hadn't really ought to be a bylaw that bans drones because there's already legislation that exists to deal with it. So whilst they are creating bylaws in various places to just say, we don't like that, or some of our constituents don't like that, so we're going to ban it outright. One of them, I was told just recently, referred to drones as missiles, which was legally incorrect for one, but altogether a bit strange. But either way, I think if the law were applied properly and it actually went to court, the court should rule that that's unenforceable because it conflicts with existing legislation. But that's just a tangent. You see, that's how we think as lawyers. We hear something, we go on a tangent. And so maritime law, in summary, is actually just really about ships and law of the sea and dealt with by the Admiralty Court. So again, just like the Strawman idea, not a separate thing, not a thing that allows you to escape from the law or from the grips of legislation and common law.
Again, though, people say, oh, well, there's a thing called the Admiralty Court and Admiralty Law. Yes, there is. It's a beautiful building. It's the rules
there
building.
Is, yeah.
Very, very spectacular. But I like
but
the
then
fact
it tells you what they do here.
We
We handle shipping and maritime disputes. Maritime, obviously, being of the sea. This includes, so if you get somebody say to you that, I stand under maritime law, well, okay, well, you must have a ship then, because this deals with collisions between ships, disputes over transport. And I had to learn about all of this years ago when I was shipping goods internationally. This was before I was a lawyer, so I had to learn about all this then. But as Al just said, yeah, it's a separate thing.
Yeah, so that's it. I mean, like I say, you can say I stand under Admiralty law, but you'd better have an oil tanker that's running around or something like that. Actually, the shipping cases are fantastic. I've done a little bit of shipping law, mainly by getting the big bumper book of shipping law out from our local library. And I was embarrassed. I had to Google what bunkering was. I did find out, though, why ships traditionally were black on top and red underneath, and they were painted black because they used to load all the coal in through the side, and it really messed up the side of the ships. So they just used to paint them black so you couldn't see it. And they're painted red because they use a special paint that's got something that oxidizes in and stops barnacles clinging to the bottom of the ship. There you go. That's why they're black and red.
Even I've learned something today. So moving finally
on art law. Oh, sorry, Dan. But on the Art Law channel, I'll be bringing this up because one of the things I want to talk about on the Art Law channel is a guy called Mark Rothko, who famously did some black over red paintings. And my argument has always been that was inspired by his shipping voyages. But also that's quite interesting because the legacy of Mark Rothko, I'm calling it, because it's basically about the fact why you should never let your friends, in quotes, sort out your will for you because they will leave your kids starving and steal all your artwork.
Indeed. More of that to come on the Art and Law channel, which will be linked in the description below. Make sure you go and subscribe there for more from me and Al. So that's linked in the description. And so finally, Magna Carta. You can read about it on the Parliament website. Now, again, at the mercy of the comments, people will be saying, yes, but this is Parliament, and of course Parliament will say this. Well, yes, Parliament's going to say this, but this is how it is. There are only 4 clauses of Magna Carta still really of any relevance today. And as you were saying before we recorded out, not even the same version that most people refer to. But ultimately, all this really refers to is trial by jury. But you go ahead on what you were going to say, Al.
No, I was just about to say, because the original Magna Carta was signed, at Runnymede in 1215, that stayed in force about as long as it took King John to go and get tooled up again. Because he was literally right now. Yes, of course I'll sign here. And as soon as he got all these guys together, it was like, they were around going, right, forget this. And it literally went away very quickly. And there have been several Magna Cartas or Magna's Carta. I'm not quite. I mean, it would be Magna Carta, wouldn't it, in Latin? So the one that is in force today, the bits of it, that's not the 1215 one. That's a later one. But yeah, there are some clauses there, but. It's not so much that the rights have vanished, it's just that they've been superseded by subsequent legislation. And also, the thing with Magna Carta is they're only really the clauses that count. All the rest of the stuff is just basically whether you can put fish weirs in the Thames. You know, it didn't have a lot of day-to-day relevance unless you were like incredible. It wasn't a charter for common people. It was a charter for the nobility and the barons of the day in their sort of commercial disputes with the king. It didn't have a lot for, you know, the idea that, I mean, and we know from afterwards, the idea, it's not like after Magna Carta, suddenly being a serf became like a really good deal.
Exactly. So again, just something that's been sort of misunderstood, misconstrued, respectfully, and then in the worst cases, misrepresented. But we did have a bout of businesses reading what they'd seen online. Again, the dangers of reading, you know, online lawyers who are not actually lawyers, and then following what they say. People have been, you know, fined, and in worst cases will go to prison by following what is ultimately bogus advice. So if you want proper advice, which this video isn't, by the way, but if you want proper advice, go and seek it and go and pay for it. And then I've actually said to somebody before, if you want me to tell you what I've just said as advice, it might well be the same thing, but you have to pay me for it, and then it will be advice. But otherwise, it's not advice. So there it is. Many of the things that we hear of that are misinterpreted, misconstrued. And just to reiterate right to the top of the video, don't get somebody to go and change your meter. There's been an explosion in a town fairly close to us in Cannock, and there was a huge explosion this morning. There's a raging fire. I don't know what's caused it. My first thought was somebody's been tampering with a meter and it's gone boom. That was my first thought, and I hope I'm wrong. I mean, it's happened regardless. I hope no one's been hurt. I haven't caught up with the news, but this is doubtless, if people do start doing this, it will happen. Something will go boom and it will hurt people. So please don't do it. Tell anyone that you think might be thinking about doing it not to do it, and that you heard it here, and send them here. So with that, any closing words, Al?
No, just it's nice to be back. That was a nice little miscellany, a variety of variousness, to steal a friend's title from a friend's radio show. But I hope people enjoyed that. And yeah, we'll chat on future occasions about all the... you know, why we always say it's advice, not but it's guidance, not advice. But yeah, we keep coming back to this thing that the law, it can be complex and it is difficult accessing the law, but there are ways of doing it. And I would just come back to this: check your sources, including us. I mean, Dan, Dan and I, we hope that we can always at least link to you the primary legislation or the thing we're referring to, so at least you can check the source out yourself. But yeah, stay safe, stay warm. Don't blow yourselves up or electrocute yourselves tampering with meters.
Indeed. Wise words. So with that, I remind you, all of the links in the description below, certainly to the Art and Media Law channel, which is starting to grow. More content to come there. Please make sure you like this video if you haven't already. Make sure you are still subscribed. And as always, thank you so much for watching.